Welcome everyone. Bonjour à tous. Buenos días. Kalimera. I have only 5 minutes in order to sparkle your scientific interest, and 5 minutes as a Greek lawyer, this is a mission impossible, but I will try to keep it sweet and short. Let us have together a first glance on the contents of the third issue of our journal. In the third issue, you can find a variety of articles on cooperative law coming from Europe and Africa, legislation updates on cooperatives from Belgium and in the Basque countries, event reports on cooperatives and the pandemic, and also on conferences that have taken place in Berlin and in Costa Rica. In the special section on cooperatives and other fields of law, in this issue, the author examines the French and the European competition law regarding cooperatives. When it comes to the practitioner's corner, where we discuss the practical side of cooperatives and cooperative law, in this issue, the authors talk about the indivisible reserves from a European comparative perspective. Also, we have a comment on the cooperative banks regarding market and competition, and also a comment on the recently enacted cooperative legislation in Australia. In the book reviews, in this issue, we have added announcement of publications, where we provide space for the authors to present their work that focus on cooperative law. And last but not least, as with every issue, we end with an interview given by an eminent scholar. In this issue, we had the pleasure of interviewing Dr. Gema Fajardo. Gema, muchas gracias. And Gema shares some insight on the development of cooperative law and the changes in the field of cooperative law, among other interesting things. We all look forward to your presentations and the conversation that will follow. Thank you.
Manuel Marino. Sont actuellement appuyés, rétablir.
Okay.
Sont actuellement activés. Appui.
Thank you very much, Iphigenia. So we are going to start with the core of the webinar. We are very happy to have so many of you with us, and it is an opportunity to give a flavor to the attenders of the thoughts and the questions arisen through this issue. We will do we will have only 5 minutes for each speaker, and we'll try to have 1 or 2 questions after each speech, each presentation, if there is any, of course. As you know, all the speakers are allowed to speak their mother tongue, so feel free, of course. And that's it. So I first give the floor to Willy Tajic, because well, there are some of you have got some constraints or other occupations, other business, and Willy is going to speak about the harmonization of cooperative law in Africa. The floor is yours, Willy.
Thank you so much, David. I hope you can listen to my voice. Yes, the paper is about the standardization of cooperative law in Africa, a comparative analysis of OADA Uniform Acts related to cooperative law and the East Africa Community Cooperative Societies Bill. I will differentiate the content of the presentation in 2 parts. So first of all, I will present the organizations, mainly the OADA organization and the East Africa community. And secondly, I will talk about the different acts in the two regions. So OADA is an organization with the mission, with the aim to provide business law rules, and it is not dealing with economic integration, unlike East Africa Community, which is an economic organization that uses law as a means to achieve economic integration. So under the OADA space, there are two regional organizations that have economic integration missions, namely the West Africa Economic and Monetary Union and the Central Africa and Monetary Organization. So both of them are economic organizations, and they have almost the same mission like the East Africa Community, dealing with the economic integration, but they work closely with OADA, whose mission is only to provide for business law rules. So sometimes there can be competition amongst their different acts that they provide in the field of business law. The two organizations has engaged process to adopt an act dealing with cooperative law, but the first was the OADA 10 years back. And the Uniform Act is implemented since May 2011. And in the East Africa Community, the act is not yet applicable, it is still a bill. So the process started in 2014, but it is not yet applicable because the process of the legislative process is not yet finalized according to the East Africa Community Treaty. But we compare the two acts, taking into consideration, assuming that the East Africa Community is already implemented. So on the adoption procedure, the first finding we have allow us to say that in the OADA case, it looks like the Uniform Act was some kind of work of experts with less implication of different stakeholders in the cooperative movement. Why do we say that? We realize that after the adoption of the Uniform Act, many people were surprised at the release of the Uniform Act. And up to now, in many countries, there's still problems in the real application of the Act. And when we compare this adoption procedure in the OADA zone with the same procedure in East Africa, you can realize that the process was more concerted in East Africa, with a real implication of different stakeholders at different levels, and with the consideration of views and the comment of all stakeholders, of all actors from the cooperative field. So we are then facing with two experiences of standardization of cooperative law in Africa, and the attempt is to see exactly what they have in common, what we can compare them, on what point we can compare them. So we cannot mention all the points in the different acts, so we will mention only five points, 5 elements. The first one is about the typology of cooperative. In the OADA zone, we have two types of cooperatives, mainly the simplified cooperative and the cooperative with board of directors. When we see the legislative process, we can realize that they provided for two types of cooperatives to consider the existence of groupings in some countries in the OADA zone. And the idea was that the grouping will function under the SCOPS, simplified cooperative rules, and the former cooperative will be run under the cooperative board rule. But unfortunately, that statement was not mentioned in the Uniform Act. And up to now, cooperatives have to choose between the two types of cooperatives, and the groupings are still available in the different country where they were existing in the past. And in the East Africa Bill, there's only one type of cooperative, so there's no distinction of cooperative like in the OADA zone. And the second point that we can mention is about the apex bodies.
Excuse me, Willie, be careful,
Yeah.
you only have 2 minutes left.
Thank you, David. So concerning the apex body, in the OADA zone, there is a freedom to have as many as possible national cooperative apex organization. But in the East Africa zone, the bill provides only for one national cooperative organization, one national cooperative apex body. The third point is about audit. There is no system of audit in the OADA Act, and in the East Africa Community Bill, each cooperative is obliged to provide for a cooperative audit and a financial audit each year. And last point we can mention is about the policy. So there's nothing mentioned about policies in the OADA zone, but in the East Africa Community Bill, there are tax exemptions, for example, that are provided for cooperatives. So to conclude, we can say that, or we can suggest that the OADA Cooperative Act should be maybe modified or amended, taking into consideration inspirations from the East Africa Community experience, at least concerning the adoption procedure. That can be a useful tool for the OADA zone to consider the view of the stakeholders during the adoption process. So let me stop here, and if there's a question, I am available to answer, to stick with the time. So thank you, David.
Thank you very much, Willie. So you've been obedient. It's good. So
yeah, and I'm very sorry for that. I'm attending a workshop today, and I can stay longer. Yeah.
Okay. If there is one question, we can have 1 minute for one question. If there is no question, I have one myself, so I allow myself just to know, is there any discussion between OADA and the Eastern Africa organization about these regulations on cooperative law?
Up to now, no attempt to start a discussion, but we are trying to do that. As you know, we have engaged in the process of assessing the Uniform Act, the OADA Uniform Act, after 10 years of implementation. And what we are trying to do is to see how we can approach the ICA office in Nairobi to have a workshop, a colloquium in Nairobi, to discuss the OADA Cooperative Act with our counterpart from East Africa, to see how we can share experiences on the issue of standardization of cooperative law in Africa.
Okay, good. So we are waiting, looking forward to attending virtually, at least, to that conference in Nairobi, if possible.
Of course, you will be
Thank you very
invited.
much, Willie. And the time is now to give the floor to Cliff Mills, who will speak about indivisible reserves. So, Cliff, the floor is yours.
Thank you, David, and greetings to everybody. So yes, the paper I have written on indivisible reserves is a high-level review of how EU member states approach indivisible reserves with a view to making recommendations to lawmakers. This was part of a bigger document which is referred to in the journal, and that bigger document is called Who Owns Europe, which was written for the Foundation for European Progressive Studies. And it explores not just who owns Europe and its institutions and its land and its assets, but the nature of ownership, and particularly of corporate ownership. And it is exploring the implications of corporate ownership for investment by investors, and seeks to argue why progressives should focus on cooperative and democratic forms of business ownership and press for legislation to encourage them and to encourage corporate diversity. And this paper that's now published in the journal was an appendix to that in that document, and it explores indivisible reserves because they are obviously a key element of the distinctiveness of the cooperative form of ownership. And in a sense, the main finding of the study is not at all surprising or dramatic, which is that there is a very wide variation between the 29 states that I looked at in relation both to indivisible reserves and the supportiveness of cooperatives through their laws. And as I say, that wasn't surprising, but I think for me, this was my first journey into comparative study of different states. And it was a real awakening to see how underdeveloped the law is in the UK in comparison with other states. To undertake this review and explore how different states deal with indivisible reserves, I went right back to the beginning and started with, do the national constitutions recognize cooperatives and speak about cooperatives? And I was greatly indebted to Iphigenia's work on this. Her study of those states who cover these matters in their national constitution, but then to look at each state to see whether they have a separate cooperative law, whether they define cooperatives, what is the nature of capital, and then whether they have investor members, before then coming on to the main question, do the laws require a portion of surplus each year to be put into indivisible reserves? And are those indivisible reserves then protected? And as I say, the outcome of the study, which I hope is sufficiently well presented in tables with perhaps oversimplistic representation of the answers, is helpful, but it shows a huge variation between those states who go to great lengths and protect indivisible reserves, both on a winding up of the cooperative or potential conversion into another type of entity at one end of the spectrum, through to those that provide no protection. And I think there were three big kind of takeaways for me doing this study. The first was the importance of the reference in the national constitution, which of course is something that is very hard to do. There isn't a regular opportunity to change a national constitution, but it has made me realize that it's not just the national constitution. There may be regional, there may be local authorities, local councils, and the ability to refer to cooperatives in these important constitutional documents, I think is really significant, and we shouldn't just be thinking of the national constitution. The second takeaway was how important it is to define cooperatives in order to protect their identity in law. We don't have that in the UK. We're better served now because we have clear guidance from the registrar, the Financial Conduct Authority, as to what they regard as enabling a society to register as a cooperative, but it is not enshrined in law, in legislation. and therefore that is a disadvantage. And my third big takeaway from this study was the importance of comparing different states and their legal systems. And in a way, this underlines the importance of the ICA's legal framework analysis. It's a really important project that enables each of us then to be able to see how our own national laws compare with others, and that we can then support each other in taking forward reforms as and when appropriate. And I think the last thing I should do is to apologize to everybody. I'm an English lawyer that's not qualified to talk about anybody else's laws, and here I have talked about 20 other states. So you're welcome to ask me any questions, but I don't admit that I'll be able to answer them, but I'll do my best on any questions and the approach I've adopted. So that was just a very quick review of my paper.
Perfect. Thank you very much, Cliff. Yes, if anyone has got a question.
I have a question.
Yes.
Can you mention your second review, your second point of the review? The first one was the importance of reference to cooperatives in the national constitution and other lower level laws. And the last one was importance of comparing different states and the legal systems, but I didn't quite get the second one.
Thank you. The second one was defining in the law itself what is a cooperative. A number of states are very clear, different approaches are taken. More commonly, it would seem they go back to the ICA statement, but it enables clarity for those people wanting to know what is a cooperative and what is not a cooperative in law. And I think this is really important because, for example, if you want to be able to encourage cooperatives, let's say with tax advantages, if you can't define what is a cooperative, then you have no ability to encourage cooperatives with tax advantages. We have that in this country for charities, for philanthropic organizations. It's very clear what is a charity, but we do not have the same clarity about what is or is not a cooperative, and therefore it's not possible really to argue for different treatment by tax authorities or by regulators or that kind of external body.
Can I ask just one more question?
Very quickly.
Okay, I'm a bit shocked there because catching up on the history, the beginning of cooperatives, it started in England, if I'm not mistaken, in the UK. And it went, from what I read, through several processes as to how to define it. But if you're telling me that up to now in the UK, it's still not perfectly or completely defined, it comes as a surprise to me.
Yes, it's a very good point. It's a surprise. I think it's more of a shock to me because
I didn't want to say that, but I'm shocked.
We think of Rochdale as the place where it started, but
yeah,
it wasn't until 2014 that the word cooperative appeared in the title of legislation. For a long time, it was called Industrial and Provident Society Acts. And the reality is that the law, whereas in this country, every 20 years or so, every generation, company law is completely reviewed and rewritten to make sure it is fit for purpose. We've never done that for cooperative law. It was written in 1852 for the first time, and it evolved over the next 20 or 30 years. But really, it hasn't changed substantively. There have been some small changes, but we've never sat down and said, what would good cooperative law look like in the UK? What are other states doing? That has never happened here, and so we are at a disadvantage. We're a long way behind.
Thank you very much. So, well, I apologize, but we don't have time for more questions, and I will myself be frustrated, but well, so it is. So now I give the floor to Aneta Suchon. Hello, Aneta.
Yes, I'm here.
Who will deal with the question of multifunctionality in rural areas through the Polish cooperative law. The floor is yours, Aneta.
A lot, but I have a question. Do you see my presentation? Sorry.
Yes.
Yes.
Sorry?
Yes. Yes. So at the beginning, I would like to thanks a lot that you published my article about cooperatives in the process of multifunctionality development of rural areas in Poland, a selected legal issue. I am a lawyer and I occupy generally about the agricultural law and cooperative law. That's why I have chosen this this subject, yes, to connect rural law, agricultural law, and cooperative law. Cooperatives contribute to rural development, which are an important part of the European Union, and a lot of people live in the rural areas in the member states of European Union. And more countries, however, do not connect their professional work with the agricultural activity. So that's why also it's important to increase the job in the rural areas because the unemployment rate there is higher than in the rural area. And in Poland, the cooperative has in Poland the cooperative has a big history. And cooperative has been operating in areas for years. And of course, they are associated with the agriculture sector and others. And as I mentioned, the subject is important in our country because in Poland we have a lot of farmers and this sector is very important. That's why also cooperatives are important, and we have in Poland more than 10 branches of cooperatives. For example, we have dairy cooperatives which are popular and they have a big history because milk market is also very important for Polish farmers. And we have also supply and sell cooperatives. We have cooperative groups of agricultural producers connected with the European Union because this kind of cooperatives can receive money from European Union. We have cooperatives bank and we have social cooperatives. And I would like to say more maybe about this kind of cooperatives because they are new cooperatives and I think they are important in our country. And we have also some example of the energy cooperatives, but there is not a lot of, but our legislation has been changed some years ago, and I hope maybe in the future we will have more energy cooperative because in Germany there is more than 900 such cooperatives. And maybe I omit the purpose of the paper because I have only, I think, 2 minutes. In this article, I have mentioned about the concept of both multifunctionality on villages and stable development of rural areas because it's also very important for our country, as I say. And this concept aims at supporting a diverse business activity on these areas, creating new workplace, improving the living condition, providing the residents and business with the access to a wide range of services of modern infrastructure. And as also said, the agriculture cooperative are very popular in the field of agriculture. And of course, as I mentioned, we have different kind of cooperatives and we have a big history. And this is the person who created the first cooperatives. This was Stanisław Staszic, and it was in the 1916, and this person established Hrubieszów Agricultural Society in order to improve agriculture and industry and to provide mutual assistance in misfortunes. And after the First War, we have a new act, very modern. It was in the 1920, and of course, socialist time was not very good for our development of cooperative. So maybe we have a lot of cooperative during socialist time, but they not fulfilled all the the important maybe rules for the cooperatives. And after our coming to European Union, we have new opportunities because agriculture producer groups can receive money, especially fruit and vegetables producer groups cooperative. And we have also some example of organization, but only fruit and vegetables. So I think there is now more opportunity for the cooperatives, and we have also new regulation. This is the old regulation from 1982 about dedicated for all the kind of cooperatives, but we have also act on social cooperatives who are very important in rural areas. We have more than 1,000 of such cooperatives which help people, unemployment, because unemployment is high, people who are ill, yes, and they need job. And we have also new act about the farmers cooperatives from 2018. So of course there is a lot of different act which have influence on functioning of the cooperatives in rural areas. So I have, in this article I have mentioned about some of them. More attention I put to the social cooperatives, as I mentioned, because they are popular in our country, not only in rural areas, but also in the city. In Poznań, where I live, we have a lot of such cooperatives. And as I mentioned, especially for agriculture, the joining together farmers are important, because in Poland we have 1 million of agriculture holding. Yes, so it's important for the competition to work together. I have mentioned about some EU regulation and about some maybe program dedicated to the Polish producer, and I mentioned also about the law on renewable energy sources, because we have the definition of the energy cooperative. So summary, so I minutes. So Polish cooperative has a long history, and Poland's membership European Union has created new possibilities of development of the cooperative movement. There are diverse entities in the cooperative movement. On the one hand, they work to order to make the members agriculture producer more competitive on the European market, and on the other hand, to achieve social goals and development of agricultural activity. The most popular in rural areas is closely related to the multifunctionality of the villages and sustainable development of rural areas. So I think that, I hope, yes, that in the future we'll have more cooperatives, and we have also new law for dedicated for the cooperative. Yes, so I am, be honest, I think that we will have in Poland more and more cooperative. Thanks a lot.
Thank you very much, Aneta. I fear that the time has run, and that we will not have time now for a question. It's the game. Sorry, but
Couper mon audio. Bouton. Agent activé là.
So I will. I will jump from Poland to Greece, but remaining into rural areas. And so Michael Fefes will deal with the difficulties of farmers' cooperatives in Greece. The floor is yours. Michael Fefes, can you hear us?
Appuyez rétablir.
Hello.
Hello, Michael. You can go. You can start.
Microphone is muted.
Because I missed. Just
but now we can hear you.
You can hear me. Sorry about that, because there are specific technical difficulties in this house. So I was supposed, I will not take my main purpose. Thank you everybody for being here at first, and good evening to everybody. Sorry about that. I was in a little bit of a panic because I was trying to connect through two different devices. Anyway, I'm through a tablet now. I'm happy that you can see me and you can hear me. I will not take much of the time. My basic argument is that in Greece, at least, the special legislation designed for agricultural cooperatives has played actually a detrimental role for cooperatives themselves. The reason I'm telling this is that agricultural cooperatives, since the beginning of the 20th century, when the first law, the first general law of cooperatives was promulgated, were seen as a tool for, let's say, political tutelage of the agricultural voting. So the main concern of the state was to control such vote through issuing legislation every now and then. Recently, I can count since 1979, when there was the first specific legislation issued for agricultural cooperatives. We can count at least maybe 7 or 8 basic laws, agricultural cooperatives. In my paper, which thank you so much for publishing it in the 3rd issue, I was trying to prove through explaining the basic points of the, let's say, 4 of these specific laws, the deficiencies that played a major role, so that if you ask nowadays the public opinion in Greece, what do they think about agricultural cooperatives? Unfortunately, this public opinion is mostly negative as regards cooperatives in a whole, because you see the main type of cooperative that was advanced in Greece was the type of agricultural cooperatives. So this as an introduction, I will not take much of your time. I'm telling this again. I will just say a few words as regards the deficiencies of the very recent law of 2020, namely 4673. I have to point out that each Minister of Agriculture coming in Greece thinks as, I don't know, a sacred duty to issue his own law for agricultural cooperatives. I'm telling this because the previous piece of legislation was Law 4384 of 2016, which was issued by the previous government. When the current government has come into power, the new Minister of Agriculture issued the current legal regime, annulling the former legal regime. I only will tell you that this annulment was not important, because more or less in most of the articles, the new law is a copy-paste of the old law. Anyway, I will finish by pointing out 3 basic deficiencies of our current legislation. The first deficiency is that it provides that besides what is regulated by the current law, there is a supplementary application of the law concerning sociétés anonymes. Well, I consider that this specific supplementary application is is irrational, because everybody knows that when we want to compare cooperative with another kind of company, in order to point out what should not be done in cooperatives, we point out to Sociétés Anonymes, which is another entity regulated and functioning with a completely different way than the cooperatives. Nevertheless, our legislator considers that this specific law on Sociétés Anonymes is perfect to be supplementary, I say, applied for agricultural cooperatives. This is point one. The second point is that they provide for investor members, which is fine as a first step, but on the other hand, it provides that investor members will have a voting, the right to vote in a General Assembly of the members, and moreover, they can control, this is the wording of the law, 35% of, up to 35% of the votes in a General Assembly. This specific provision is not proper because it violates, if I remember well, the third cooperative principle. The third point I want to mention is that the new law provides that if an agricultural cooperative is winding up and liquidated, is wound up, sorry, and liquidated, then the remainder of the liquidation, if any, of course, will be distributed to the members. And so this means that any generation of members of a cooperative may at any time dilute the cooperative and distribute the cooperative property among them, which means that this is completely against, again, of the third cooperative principle. Furthermore, the new law just goes on to provide for the same, actually, deficiencies that existed in the previous law. So I don't think necessary to say it one by one. The only thing I would like to point out in order to reinforce my argument as regards the political tutelage of the agricultural voting is that this law again provides that there will be no members registration 3 months prior to the date of election of the members of the board of directors, which is, I cannot understand why this should happen. It's obvious that the minister and the legislator are afraid that if we accept members in the cooperative 3 months prior to the election, this will be because we will want actually to control the voting for the board of directors. There is a mandatory presence of a lawyer at the procedure of elections of the board of directors. This is a unique provision only for agricultural cooperatives. In no other entity, be it commercial entity or an NGO, as for example an association, there is no provision that for a compulsory mandatory presence of a lawyer during the elections. And
Michael, only 3
okay,
seconds left.
Yes. No, it's okay. I think there are some more points, but there's no time to say it one by one. Last point, and I finish with this, that in the new law, as in the previous law, there is a distinction of cooperatives between mixed cooperatives, let's say it, and purely female cooperatives, which is a violation of the first cooperative principle. I know that there are female cooperatives, but this happens, as ICA explains, in countries where, you know, there is no, let's say, equality of both sexes, and the place of women in these countries is not the one that we could say that happens in, let's say, Western countries. I don't see why in Greece, where there is an equality of sexes both in our constitution and in all our legislation, should exist, okay, should exist just female cooperatives. Thank you very much. And
thank you very much, Michael. Well, unfortunately, the time is off, and we will not have time for any question about that presentation, and it's a pity. So I remind to the speakers that if you go over 5 minutes and till 10 minutes, then you will not have the opportunity to get any question because we don't have time. I apologize for that. Anyway, so thank you very much, and
thank you.
It's quite common that cooperatives face competition difficulties, so it's just time to go and welcome Sophie Grand-Villemain. And Sophie, I'm very happy to welcome you, and I thank you for the article that you proposed. What is quite funny is that we are quite close all together, and we have never met. So, well, it will happen sometimes. Sophie, merci beaucoup, et je te laisse la parole.
Thank you, David. I'm happy to see you. I prefer express myself in French. I'm sorry. Bonjour à toutes et à tous. Je suis ravie de participer aujourd'hui à cette manifestation pour le lancement du 3e numéro donc, de cette belle revue. Je voudrais aussi, bien sûr, remercier les directeurs et directrices scientifiques de m'avoir permis de contribuer à cette belle revue internationale consacrée au droit coopératif, droit qui me tient particulièrement à cœur. Au-delà du droit coopératif, dans mes recherches, j'ai 2 thèmes de prédilection, l'économie sociale et solidaire et le droit de la concurrence. J'ai trouvé stimulant d'allier ces 2 thèmes dans ma contribution en étudiant la confrontation au droit de la concurrence des relations qu'entretiennent les coopératives avec leurs adhérents. Les sociétés coopératives exercent une activité économique sur le marché, elles sont soumises au droit de la concurrence. Mais vous le savez bien, les coopératives ne sont pas des sociétés comme les autres et leurs membres ne sont pas de simples associés, ce sont des associés coopérateurs. Cette double qualité fait toute l'originalité des relations coopératives, relations qui elles-mêmes participent de la richesse du droit coopératif. De son côté, le droit de la concurrence est réputé être insensible aux spécificités statutaires des entreprises. Alors, on peut se demander comment il appréhende la singularité des relations entre les coopératives et leurs membres. Eh bien, en cette matière, il n'y a pas de réponse univoque. Le droit de la concurrence est multiple. J'ai donc distingué dans ma contribution entre le droit des pratiques anticoncurrentielles et le droit français des pratiques restrictives. S'agissant d'abord du droit des pratiques anticoncurrentielles, j'ai centré mon propos sur le droit européen et le droit français. Alors, le droit des pratiques anticoncurrentielles prohibe les ententes et les abus de position dominante. Ce sont des pratiques qui perturbent le libre jeu de la concurrence sur le marché. Et le droit des pratiques anticoncurrentielles a pour vocation de protéger non pas les concurrents en eux-mêmes, mais le marché dans son ensemble. De plus, le droit des pratiques anticoncurrentielles, c'est un droit du comportement régi par un principe de neutralité statutaire. Cela veut dire que ce qui l'intéresse, c'est le comportement des entreprises sur le marché, pas leurs caractéristiques propres, leurs caractéristiques statutaires. Donc, pour dire les choses simplement, le droit des pratiques anticoncurrentielles n'a que faire des spécificités coopératives. L'organisation coopérative, quelle qu'elle soit, est perçue comme d'autres formes d'organisation, comme la source potentielle de pratiques anticoncurrentielles. Dans ce cadre, les relations entre les coopératives et leurs entreprises adhérentes sont traitées comme toute autre relation économique sur un marché. Alors, comme je le vois dans ma contribution, les modalités d'adhésion, de retrait ou d'exclusion des coopérateurs, les exclusivités, les obligations de non-concurrence, les politiques communes sont appréciées en fonction du contexte économique dans lequel elles interviennent, en fonction de leurs seuls effets concurrentiels sur le marché. Le marché est le maître mot. J'en conclus donc, dans mon étude, que le droit des pratiques anticoncurrentielles banalise les relations coopératives au nom de la protection du marché. La situation est tout autre s'agissant du droit français des pratiques restrictives que j'aborde également dans mon étude. Alors, contrairement au droit des pratiques anticoncurrentielles, le droit français des pratiques restrictives a pour vocation de protéger non le marché dans son ensemble, mais les entreprises dans leurs relations individuelles. Le Code de commerce français prohibe certains comportements introduisant un déséquilibre dans les rapports entre clients et fournisseurs. Dans ce cadre, le droit français des pratiques restrictives peut-il vraiment protéger les entreprises dans leurs relations avec leurs coopératives? Alors, la réponse apportée par la jurisprudence française que j'expose dans mon étude est sans ambiguïté. Le droit des pratiques restrictives n'a pas vocation à régir les relations coopératives. Alors, ce sont des relations internes au groupement coopératif. Elles sont le fruit d'un subtil équilibre entre les intérêts de chacun, coopérative et coopérateur. Elles ne peuvent donc être appréciées qu'à l'aune du droit coopératif, à travers ses lois, les statuts des entreprises et leur règlement intérieur. Certes, le droit des pratiques restrictives est souverain pour réguler les rapports entre partenaires sur un marché, entre clients et fournisseurs. Il ne peut en revanche s'immiscer dans la sphère privée de l'organisation coopérative. Ce serait à mon sens réduire la relation coopérative à un simple rapport commercial de marché. Le droit des pratiques restrictives, le droit français des pratiques restrictives, ne peut donc que s'effacer, laissant le champ libre au droit coopératif. Pour conclure, je dirais que l'empire du droit de la concurrence s'arrête là où commence ce qui fait l'intimité des relations entre les coopératives et leurs membres, le pacte social. Je vous remercie. Thank you.
Thank you very much, Sophie. Merci, Sophie. I think that we have 1 or 2 minutes for short questions. Is there any question? Sometimes I'm, well, I can't say happy, but not unhappy if there is no question, because I have time to ask myself one. I would have myself one question. J'aurais moi-même une question presque naïve. Est-ce que la différence, l'opposition qui existe dans les deux approches, je dirais, favorables à la coopérative ou favorables au droit de la concurrence, sont liées à la question, à l'objet, au thème, ou est-ce que c'est lié à ce que les pratiques restrictives ont plus d'indépendance en droit national par rapport au droit européen, et donc est-ce qu'en fait ce n'est pas les sources nationales et les sources européennes qui divergent?
Alors, c'est une bonne question. Je me suis moi-même posé cette question. Après, il est vrai que, en réalité, ici, ce qui fait la différence, à mon sens, c'est que le droit des pratiques restrictives, ce que j'indique dans mon étude, est vraiment propre aux relations individuelles aux relations commerciales individuelles et le droit coopératif, les relations coopératives au sens individuel du terme ont une dimension autre que commerciale. Elles ont également une dimension commerciale, mais elles ont aussi une dimension sociale et à mon sens, le droit des pratiques restrictives n'a pas sa place dans ce cadre. La Cour de cassation aurait pu justement, la Cour de cassation est habituée quand même aux questions concurrentielles, elle peut être aussi influencée par le droit européen et donc aurait pu avoir une approche purement concurrentielle. Mais je pense qu'effectivement, ce qui a prédominé ici dans la jurisprudence française, c'est aussi le côté interne des relations coopératives qui fait qu'en réalité, le droit des pratiques restrictives n'a pas sa place. Et d'ailleurs, j'en veux pour preuve que la Cour de cassation a adopté le même type finalement de position pour d'autres groupements auxiliaires d'entreprises, comme les GIE par exemple. Donc, je pense que c'est plus un problème de caractère interne des relations coopératives, de leur richesse aussi, que le caractère national du droit des pratiques restrictives.
Okay, thank you very much, Sophie. We are just moving beside France, not very far. We are going to hear Maïka Bernatz about the new Belgian cooperative legislation. Maïka, you've got the floor. I don't know if you want to speak English or French, I don't know, or maybe Flemish, I don't know.
Thank you. I will speak English for everybody to understand. So, hi everyone. My name is Maïka. I'm working as a lawyer, specialized in company law in general, and I work a lot with cooperative. We decided with my co-author Thierry Tilquin and Juliane Delcor to present the new legislation on cooperative companies in Belgium, because it has recently been modified as part of a wider company law reform. The reform started quite badly for cooperatives because the initial plan of the Belgian legislator was to drop purely and simply the cooperative society form. So it was deemed not necessary. So they wanted to delete it. And thanks to some cooperative lobbyism, if we can call it that way, the reform was modified, the cooperative society form was kept, and it was even ultimately particularly interesting for cooperative companies, because under the previous legislation in Belgium, basically any company could be a cooperative company. There was no need to respect any cooperative principle or any form of organization that was close to the ICA principle. So basically lots of companies were organized in Belgium as cooperative companies because it was a very flexible company to organize, especially in the way that shareholders could enter and leave the company very, very quickly and way more quickly than in other company forms. So the numbers were a bit wrong in Belgium because there were lots of cooperative companies, but not lots of what we can call true cooperative company. Now, since last year, the cooperative company is more accurately defined in Belgium. It's a big change because basically the definition of the cooperative company has not been changed since 1873 in under Belgian law, so since the start of basically cooperative companies in Belgium. And now it's defined, and any cooperative company must detail the cooperative purpose that it follows and the values that it will defend. So the definition is largely based on the definition of the European cooperative company. So we inserted in our paper kind of a chart showing the differences and especially the common points between those two definitions. And it's good to know that the ICA principles are not directly mentioned in the law itself, so they were not transformed into legal rules that have to be followed by each company because it was deemed to be too difficult to find really legal rules that would have to be followed by each company, each cooperative company, as their organization may vary. We heard from other people that there were indeed lots of different kinds of cooperative company, from the banks to the agriculture sector. So it's very different. But the legislature mentioned the ICA principle in Belgium in what we call the parliamentary works. So all the documents that are around the law. For the other rules of organization, they remain quite similar. But what I wanted to stress in this presentation, and what I think is important, especially for those of you who do comparative law and examine the case of Belgium one day or the other, is that in practice, this big change is a good change for the cooperative sector, but it means that the number of cooperative companies in Belgium will probably, well, very likely drop drastically, if not this year, in the next few years, because the company have until 2024 to modify the company form. But the remaining cooperative company will be real cooperative company as seen by the international community. So it's a good point, even though it means that there will be less cooperative companies in the future in Belgium. Thanks for.
Thank you very much, Mika. You've been very short, and so it's very good. So that you can get some question. Is there any question?
If I may,
during the time that people think of question, just a very short question. It's a little bit surprising, of course, that in Belgium law, cooperatives could have disappeared. And the argument was that it was only a question of label, and that the same results were possible through other legal forms. Do you agree, and do you think that actually to have or not cooperative as a legal model in Belgium law is a question of label, or is it anything more?
I think it's a bit more, because I don't think labor cooperative are more represented than others in Belgium. We have lots of cooperative banks, for example, or cooperative of producers. But I think indeed that the legislator was trying to simplify company law in Belgium, and he was not, well, the amount of real cooperative is not huge in Belgium. And so I think he thought, okay, there are not that many companies that are concerned, and many of the cooperative companies are not real cooperative companies, and they can just use another form of company if we manage to make that other form as attractive as the cooperative company. And that's why it was almost deleted. And then several associations of cooperative came to the legislator, knocked at the door and said, hey, it's not because we are not many that it's not important to keep us. And they actually used the ICA principle to show that. And the fact that many international organizations said that cooperative companies were important for sustainable development, for example. So that's what saved the cooperative. But I indeed think that it would have been possible to organize a cooperative without the cooperative company form, but it would have been less less attractive and less of a label. Something would have missed for the cooperative sector, I think, to not have their own form of company.
There is also a question, sorry, David, for jumping in. There is also a question by a participant towards you, Micah. Thank you for the presentation. I'm going to read. It's from Govindaraj Verakumaran. Sorry for mispronouncing. The participant asks, does Belgium cooperative companies are functioning in the service sector, or are they limited to the agricultural value chain? Thank you.
So cooperative companies in Belgium can work in about every sector and can do about every services they want. So we could have a lawyer cooperative if we want, if we are organized according to the cooperative principle. We have lots of pharmaceutical companies organized as cooperative. So really, it's not at all limited to the agricultural chain. And there are basically, I think, in Belgium, more companies in other sectors than the agricultural sector than in the agricultural sector.
David, do we have time for one question from me as well? Maybe you should one.
It's from you, yes.
Okay, great. So, Micah, one question from the political side, actually. If I have understood you well, the reform of the law can be considered as a product of co-construction, since there was an impact from the cooperative sector. How long did it take, the co-construction, the discussions, and also why do you think cooperatives were able to influence the direction of the legislation?
So the first discussions were started in 2014, so 5 years before the legislation was implemented. But it has to be noted that the justice minister at the time was a former lawyer. And so he had defended as a lawyer the fact that we need to suppress many forms of companies. But then when he became minister and he had to go on with the reform, thanks to the federal system of Belgium, he needed other political party to go on. And so cooperative companies managed to convince some mostly left-wing political parties that cooperative were really important. And so that was a bit of a game of, if you reintroduce cooperative company, then we agree to accept some of the rules on other companies. And that's how it played, in fact, until the very end. And in Belgium, the government dropped, even in between the first decisions in the parliament about the cooperative company and the final act. And there as well, it was playing a bit with the political parties that were still there, saying, okay, if we accept this on cooperative, we might say no to other things. And so it was really a ping pong game of accepting one thing in exchange of another. And thanks for us, cooperative companies were a bit in the mixed and were one of the only demands of the left-wing parties at the time. And so it passed.
There is also one other question by Ian Snaith. David, I leave it up to you if Micah...
I'm afraid that it's, well, I'm very sorry, but I don't want to make too much time. I already think that we will be a little bit late for ending of the webinar. So, okay, thank you very much, Micah. Well, it's good as well to be late, because it means that it's interesting for, as a whole, and maybe we will have to make differently next time. Now I jump to Aitor Bengochea. I'm very sorry if I don't pronounce correctly. and you will present us, you as well, a new legislation, but in the Basque region of Spain. The floor is yours.
Thank you very much. Good morning to all. Good morning or good afternoon, I don't know. Well, I'll explain a bit the main innovation of the new Basque cooperative law. We had a cooperative law. The previous cooperative law was of 1993, and the new one is of 2019. Well, I suppose, we suppose, because the study has been made between Itziar Bianfañez and me, we think that our regard to Basque cooperative law is important, because here in Basque Country we have the largest worker cooperative group in the world, the well-known Mondragon Group, that has now 60,000 employees. Well, coming to the new law, the first thing I want to underline is that there are no substantial changes in the light of the previous law. No substantial changes, but even so, we think that there are some legal innovations that deserve to be commented, and that's what we have done in our article. Well, the new law, the 2019 law, is all an update of the previous law, but not only an update. Well, I will underline briefly some points. First of all, gender equality. There is some improvement in this field, fortunately. And as a general rule, the new law says that cooperatives must trend towards gender equality in all its bodies. So the members of all the bodies of the cooperative, General Assembly and Governing Council and all the bodies must trend towards gender equality, as I told you. Another new rule in the law is that in its first article, the new law explicitly states that all cooperatives must observe ICA principles. Well, we think this is good news, because all of us know that all cooperatives deserve to have this name, to deserve to have cooperative nature, must observe the principles of ICA. But we think that it's good to be explicitly stated in the law and in the first article, to put the cooperatives, in our case, the Basque cooperatives, in the framework of what a cooperative must be according to ICA principles. Another point that seems interesting to us is the professionalization of the administrators, professionalization of members of Governing Council of Cooperatives. Well, we think this subject is complex. On one hand, sometimes it could be a good measure, to improve the administration, to improve the technically good administration of the cooperative. But we think it could be harmful too. It could be harmful too if it means that management of the cooperative gets away from cooperative principles. The new statement is that the third part of the governing council of the cooperative can be non-cooperators, the third part. And the previous law told us that it was the fourth part. So we think this is a complex subject. More, In the point of allocation of losses and system of responsibility, we think it's very positive that the new law puts it clear that if there are losses in the cooperative, the responsibility of cooperators is limited to the subscribed share capital. And with the previous law, this wasn't clear. And it was a problem when I think it was in 2013, when the Hugh Fagor cooperative failed. A lot of cooperators were really upset with the debts of the cooperative, because with the previous law of 1993, the key wasn't clear, and some authors held that, according to the previous law, as I say, some authors held that cooperators should respond with all the goods for the debts of the cooperative. So it was a very delicate thing. So we think it's really positive that the new law puts clear the limited responsibility to the capital that cooperators have shared in the cooperative. Well, two more points. Merger and division. The new cooperative law permits trading companies of any kind to merge with cooperatives. This is a new possibility. We think this can be positive, the new opportunity. And in the same new line of flexibility, the current law permits the division of a cooperative in favor of a non-cooperative company. But it can happen only due to the needs of the cooperative in its business practice. Well, and last but not least, the question of self-management in worker cooperatives. Worker cooperatives that, as I have said in the beginning, is the most important type of cooperative here in Basque Country. Well, self-management, I want to stress that self-management is a main principle of Basque worker cooperatives. So, working conditions of cooperators are decided by self-management, and labor law is not applied. So cooperators, worker cooperators have all the freedom to decide their own labor conditions. All freedom, absolute freedom. Well, that's just one limit. The wage of worker cooperators can't be less than the minimum wage in the labor law. That's the only limit. Well, and the new law in this field of self-management extends that self-management has a new limit, and is that self-management conditions must observe the minimum labor standards of the International Labor Organization. That's to say, formally, it continues to be self-management as a way to decide the labor conditions. But in the substance of these conditions, they, as I have said, they must observe the minimum labor standards of International Labor Organization. And we think that this new measure, this new way, is really interesting. Why? We think it could be interesting to avoid fake cooperatives, because with this new rule, in order to observe International Labor Organization standards, with this new rule, we think it's good because self-management can't or couldn't degenerate in unacceptable labor conditions, leading to the...
Aitor, please.
Yes.
Can you conclude, because time is over now?
Yes. Yes. I was saying self-management cannot degenerate in unacceptable labor conditions, leading to the exploitation of paid cooperators. Thank you very much.
Thank you very much, Aitor. And well, I apologize that we will not have time to receive the questions, but at least we have had the main points of the new Basque legislation. And, okay, so now we are jumping to practitioners corner and other pieces, and we are starting with John Emerson and a point about the project between ICA and EU. So John, you've got the floor.
Merci, David. Sorry, I'm just going to start talking now. Good afternoon. Start PowerPoint. There we go. Thank you for inviting us to be here on this occasion. My name is John Emerson, and I'm a research officer at Cooperatives Europe. I'm joined here by my colleague Jeffrey Moxham, who is the ICA's research coordinator. So today I'll be briefly presenting our article, which provides an overview of the main elements appearing in the legal frameworks research under the ICA EU partnership. So this partnership is aimed at strengthening the ICA as a voice for international co-op development and increasing recognition of cooperatives in development policies and programs. So this partnership also includes research and knowledge building activities, including the legal framework analysis research, which forms the basis of our article. So this research is aimed at acquiring general knowledge and evaluation of national cooperative legal frames, as well as providing recommendations for improvements where these arise. So if we move on to the next slide, we can now start to discuss the article itself. Entitled Legal Framework Analysis and the ICA EU Partnership, an update on ensuring a level playing field for cooperatives. So this article is by myself and Jeffrey Moxham, who's also with us today. And so this article covers 4 main elements, the first of which is implementation and enforcement of cooperative law. So in short, while a legal framework might not impede cooperative development, attention must also be paid to the enforcement of any law for it to be effective. So in short, incentives for cooperatives should be accompanied by a strong system of monitoring, preferably through a system of vertical cooperative integration. What's meant by this is that basically cooperatives from the top should be given auditing responsibilities for cooperatives lower down to ensure compliance with law. So this should strengthen cooperative identity and also alleviate proliferation of pseudo-cooperatives. Freedom for collective organizing between cooperatives can also be important for ensuring this. So if we now move on to the second element, we can now talk about the cooperative legal playing field. And the point here is that cooperatives should be treated no less favorably than other enterprise models. From the study, however, we see that cooperatives are sometimes subject to the burdens of increased oversight and taxation compared to for-profit businesses. And additionally, regulatory conditions may exclude cooperatives from operating in certain sectors, hindering their ability to compete on a level playing field with other business models. So while acknowledging that international treaties and non-judicial factors are also important, legislators should aim to address these imbalances where possible. The third element I'm discussing today is fragmentation of cooperative law. So in general, regulating different types of cooperative by different special laws is something that not only appears quite often in the research, but it's also something that's discouraged from the perspective of cooperative development. Because fragmentation can not only disregard the shared identity of cooperatives, but also prevent a coherent public policy for cooperatives. Notwithstanding the fact that replacing special cooperative laws is not always feasible or desirable within the national context, lawmakers are nonetheless encouraged to ensure that laws are not more complex than necessary and strive for more coherent lawmaking in the interests of cooperative development and policy. The fourth and final element appearing in this article is up-to-date law. So overall, there's a consensus among authors contributing to this study that cooperatives benefit from legal frameworks that are up to date. For some countries in the study, the cooperative legal frameworks have not been updated in over half a century, sometimes longer, during which time the socioeconomic context has dramatically changed. Therefore, cooperative law in such countries is less likely to be fit for purpose in a modern context. So due to evidence from the study that well-drafted and modern cooperative legal frameworks can result in strong growth for cooperative numbers and the sector in general, lawmakers should encourage growth in the national cooperative movement across different sectors by updating outdated laws. So just as a final remark, supportive cooperative regulations can foster cooperative development and support a fairer, more inclusive and sustainable economy. We hope that the legal framework analysis research, which is the basis of this article, can contribute to this. Thank you for your attention, and myself and my colleague Jeffrey can take any questions with the time we have remaining, and I conclude there.
Okay, thank you very much, John.
Rétablir mon audio, bouton. Appuyer, décisionner à droite.
Is there any question?
Sous-menu audio. Sous-menu, couper mon audio, bouton.
If I may, David Hagen.
Yes, yes, of course.
John and Jeffrey, it's about the level playing field, which lawyers like to call the equal treatment principle. But never mind, the point is not here. The point is, I just came across a law which I had to comment, which exempts cooperatives from paying any income tax. The argument being paragraph 7 of the ILO recommendation 193, which says basically what John just said. You know, not less favorable then. So they turned it around and say, well, but more favorable, we may. What would you answer to this? How would you react to this argument?
I can give you an instinctive reaction, Hagen. So for me, it's an interesting point. So basically, what happens is if you treat cooperatives exactly the same as other companies, so aside from the obvious reasons you set up a cooperative to not pursue profit, but some other aim, but the issue is often it becomes difficult to. I think to encourage growth in cooperative numbers, there has to be a difference between how they are treated in the law. Otherwise, sometimes it's like, what's the point? But and so it's a very complicated question, which I don't have an answer to really. I think that if you want to encourage growth in cooperative numbers, I think tax incentives can be a way of doing this. But like, as I said, the first element, which was about implementation of the law, if the law isn't implemented properly, you do run the risk of problems like, pseudo cooperatives. And I don't know if that answers your question in any way, but.
Well, I just tried to be mean, as you might imagine. It's a very complex issue. But we come across that quite frequently. And of course, this argument is being used by cooperatives themselves very often, and very difficult to explain to them that equal treatment, different treatment, as you say, is quite okay, but preferential might not even help them. So I think they get it wrong, because in the long run, that might prevent them from becoming competitive.
No, it's a really, really good point. I think, Jeffrey, did you have anything you wanted to add to this? Because we have spoken.
I think it's a really, really interesting point. It links also reminding me a little bit of what was mentioned by Cliff earlier to this point about definition. And if that is also well clarified in the legal framework and respected, it's a bit like these incentives potentially would be a bit maybe the second level to go from there, but maybe in legal frameworks where even these questions are still, the discussion is still actually stuck at how are we defining it or enforcing it, then I think that's going to cause some inevitable difficulties. But yeah, I do very much concur there with what's been said already.
Okay, thank you very much.
Appuyez rétablir mon audio, bouton. Silex a rejoint.
Thank you very much, and we are quickly going to Holger Bliston, and who will deal with cooperative bank law. And Holger, the floor is yours.
Zoom US de Yann derrière tout. Arrêtez vidéo.
Hello, thank you very much. I hope you can hear me.
Dialogue system.
Good afternoon, ladies and gentlemen. Only by voice, invisible. Problem appears, technical problem. So I start again. Good afternoon, ladies and gentlemen. A voice invisible. I would like to thank the editors very much for the opportunity to contribute to the journal that really seems to fill internationally a gap. I'm thankful to present briefly today the idea of my article to you. My article concentrates on findings at European level. We realize an Anglo-American understanding in many fields, not only in economics, but also politics. In the financial sector, it is the draft of a banking and capital market union, which seems to be more only a capital market union for Europe in the future. Companies in the legal form of a cooperative should also follow the path of emerging, growing, and declining of companies, and should be open for investors, as well as small and medium-sized enterprises should be. Looking at cooperative systems in European countries, we see a listing at a stock exchange has become the case already for parts of cooperative banking groups in countries like Italy with Banca Popolare, France with Crédit Agricole, and Austria with Raiffeisenbank International. Part of the theoretical understanding of a market and competitive economy is that institutions that are not viable can no longer survive as market participants. But it is only superficially companies that perish. Behind them are always people whose personal circumstances are affected and who are sometimes seriously hurt. Therefore, the supporter of a market economy in the young Federal Republic of Germany, Ludwig Erhard, was persuaded after World War II that a social balance is needed, at least in the form of a social market economy. With respect to ICA Principle 3, I would argue that the indivisible reserves represent financially a social dimension within a cooperative. The higher the reserves are, the stronger this dimension becomes. Until today, many generations of members in cooperative banks have relied on the continued existence of their bank as a cooperative. They have increased and provided reserves for the current generation and for future generations. If this social dimension of cooperative banks, which is not vulnerable to capital markets, is maintained, then there's the prospect of moderating the market and price competition, similar to what happens in the housing industry. Today, banks are well advised to go back to their roots, as long as they are solid and their scope to cope not only with technologically difficult phases of change and crisis. What gives a bank even greater reason to exist today, that is, contrary to a banking is necessary, banks are not idea, that savers can trust in the institution bank and in its ability to keep money safe and with interest, on the one hand, and on the other hand, to make savings available to people and companies who need money for larger and long-term projects, certainly with regional or local relevance. This constellation is comparable to a market, but the institution is owned by its customers and is able to make socially responsible decisions about the lending of money, with regard to creditworthiness, but also with regard to the kind of project. To further enable cooperatives in general and cooperative banks, credit cooperatives and credit unions and similar banking entities in particular, to continue their social and sustainable role in an even more dynamic market and competitive economy, they need some kind of protection to persist. Then cooperatives would act and contribute based on the social dimension represented by the indivisible reserves as moderators even in a market and competition-driven economy. Thank you very much for your attention.
Thank you very much, Holger. Is there any question? I've got myself one question. Well, you presented, of course, the interests, the interest of cooperative banks and the necessity to go back to their roots. Do you think that it is possible for a cooperative bank to be big? And what do you think of the very successful big cooperative banks?
I would agree that size does not matter in terms of including membership or the voice of members. I see a disbalance between the influence of members on the one hand side and management on the other side in very large cooperatives. And I won't concentrate only on the economic success to compare cooperative banks with savings banks or private banks. I would underline their specificities, and the members should vote by contributing to the services of the bank, whether they agree with the cooperative spirit or not.
Okay, thank you for this stimulating answer.
Thank you very much.
So now I'm going the flow to Dante Craconia, Hola Dante, and who will speak about a seminar on pandemic and cooperatives, and of course Dante, you are allowed to speak Spanish.
Thank you, David, and thank you for allowing me to speak in Spanish. I know that at least 4 or 5 of the participants will understand me. En este tercer número del journal se publica una modesta contribución que realicé acerca del Congreso Continental de Derecho Cooperativo que realizamos en San José de Costa Rica hace un año. Puedo decir que se trata simplemente de una suerte de crónica periodística acerca del Congreso. Perdón. En definitiva, ¿cuál es el sentido de la nota? En primer lugar, destacar la importancia de estos encuentros que en el caso de nuestro continente llevan ya 50 años realizándose, puesto que el primer Congreso Continental de Derecho Cooperativo tuvo lugar en 1969 en Mérida, Venezuela, y de ahí en adelante se fueron sucediendo en distintos países del continente hasta el que comentamos de Costa Rica. Este congreso tuvo como principal motivo la conmemoración del cincuentenario del primero, pero ciertamente analizó temas que son de interés actual sobre los cuales ha emitido conclusiones. Quiero señalar que estos congresos, y esto me interesa destacarlo porque es parte de la estructura que han venido manteniendo y de la razón de su éxito y de su perseverancia a lo largo del tiempo. Tienen un triple fundamento. En primer lugar, el propio movimiento cooperativo, porque en otro tiempo fue la Organización de las Cooperativas de América la que convocó los congresos. Cuando esta organización dejó de existir y la Alianza Cooperativa Internacional se instaló en América, las convocatorias fueron realizadas por la Alianza Cooperativa Internacional a través de su Comisión de Derecho Cooperativo. Este es el primer pilar. El segundo es la participación de la universidad del lugar donde se realiza el Congreso, para darle el sesgo académico que corresponde a un encuentro de esta naturaleza. Y en tercer lugar, las organizaciones profesionales de abogados, es decir, los colegios de abogados de la jurisdicción del Congreso, que participan también en su organización y desarrollo. De manera que hay un trípode que sostiene la realización de los congresos y que le asegura su viabilidad, su realización y eventualmente su éxito. Esto ha venido ocurriendo a lo largo de estos 50 años y la actual realización del último congreso fue exactamente igual. Incluso en su acto inaugural estuvieron el presidente de la Alianza Cooperativa Internacional, la presidente de Cooperativas de las Américas, es decir, ese es el sector cooperativo del Congreso, estuvieron los representantes de la Universidad de Costa Rica, que auspició también este Congreso, y las autoridades del Colegio de Abogados de Costa Rica. De manera que ese trípode es el que aseguró la viabilidad y la realización del Congreso. En el orden interno, el Congreso no difirió de otros similares, es decir, se reúne para considerar ponencias que se discuten en comisiones y luego las conclusiones de esas comisiones son presentadas ante el plenario de los delegados. En este caso, los delegados fueron alrededor de 200 de 17 países de América. Pero además de las reuniones de comisión y de los plenarios para analizar los temas del Congreso, en todos los casos se han organizado también conferencias a cargo de especialistas de otras regiones que permiten a los delegados tomar contacto con la realidad y las inquietudes que existen en el ámbito del derecho cooperativo en otras latitudes. En este caso, Hagen Henry, como presidente de la Comisión de Derecho Cooperativo de la ASI Mundial, Carlos Vargas Bacerot de la Universidad de Almería de España y Eva Gaminde como vicepresidente de la Asociación Internacional de Derecho Cooperativo. Ellos trajeron al Congreso una visión que excede el ámbito continental y que enriquece el conocimiento de los delegados acerca de los temas de interés actual en otras partes del mundo. De manera que esto hace que se consolide una relación entre el derecho cooperativo continental y el derecho cooperativo internacional. Y, por fin, en este último congreso hubo también un panel que estaba integrado con organizaciones que tienen relación con la promoción del derecho cooperativo. Justamente, IUS Cooperativum estuvo allí representada y Ifigenia hizo una exposición acerca de ella. También la Asociación Internacional de Derecho Cooperativo y otras organizaciones. La propia Alianza Cooperativa Internacional informó acerca del tema que acabamos de escuchar sobre el proyecto ASI, Unión Europea, para el estudio de los marcos legales cooperativos a escala mundial. De manera que el Congreso ha resultado de un amplio interés que excede los temas específicos que fueron considerados. Para finalizar, quiero señalar que la influencia de estos congresos, desde el primero realizado hace 50 años hasta ahora, ha sido significativa, no solo en la promoción del interés por los estudios jurídicos cooperativos, sino también en influenciar la legislación cooperativa regional, que ha sido un efecto muy significativo de estos congresos. Y sus actas fueron publicadas y difundidas de manera tal que no solo los que participaron, sino también otras personas interesadas pudieran tener acceso a sus resultados. Por eso, en suma, este Congreso ha ratificado la línea que se viene desarrollando para promover el derecho cooperativo, tanto en la academia como en el movimiento cooperativo y en la influencia sobre la legislación, de una manera significativa. Y puedo anunciar que el próximo congreso, que se realizará en Asunción, Paraguay, en 2022, habrá de seguir en esta misma línea. Y allí espero que nos veamos con muchos colegas y amigos que incluso ya han participado en anteriores congresos continentales. Muchas gracias.
Muchas gracias, Dante. I think that it's quite well done that as you were honored in a previous issue after you come Gema Fajardo Garcia. Hello, Gema. And I'm very happy that first of all you accepted to make this interview for the journal, but also that you are present today, Gema. Well, as one of the prominent cooperative lawyers around the world, I would be very happy just to give you the opportunity to draw some conclusions, not of the seminar, not of the webinar of today, but of your experience and life as a cooperative lawyer. And so the floor is yours, and you speak either in English or in Spanish as you wish.
Thank you, David. Thank you, David. First, I'm very happy to share this meeting, but I go to do my presentation in Spanish because if there are this opportunity, I will take advance. Well, yo he participado en esta tercera edición del International Journal Cooperative Law porque me han entrevistado amablemente Ifigenia Dubitsa y Hagen Henry. Se trata de una extensa entrevista que ha dado pie para tratar diferentes temas. Hemos hablado de la economía social, de la relación entre cooperativas y economía social, del derecho cooperativo y de la propia revista International Journal Cooperative Law. En cuanto a la economía social, se planteó el papel que deben de tener estas directrices que a nivel internacional se están elaborando sobre cómo legislar la economía social. La economía social no es una forma jurídica, por tanto, cuando se habla de regular, se hace más bien referencia a medidas de visibilización, medidas de políticas públicas de fomento. Hemos hablado de la Ley de Economía Social Española, en la que tuve la oportunidad de participar, de sus virtudes y de algunas de sus carencias, del momento actual, de lo que le hace falta. Y por último hablamos también de la revista jurídica del FIDIEC, revista de Economía Social y Cooperativa, que contribuí a su fundación hace más de 30 años y he estado codirigiéndola pues durante estos 30 años. En fin, hemos hablado de ella. Ahora la revista tiene una nueva dirección, Manuel García le está dando un impulso importante. Es una revista reconocida, muy reconocida, con sello de calidad de las revistas científicas españolas. Y bueno, pues hemos hablado de su experiencia. En cuanto al derecho cooperativo, las preguntas se centraron fundamentalmente en su diversidad y en la posibilidad de su armonización. En los esfuerzos que se han hecho tanto desde América Latina, el Mercosur, la Asociación Iberoamericana de Derecho Cooperativo, pero sobre todo el grupo SGECO, Study Group o Cooperativa European Cooperative Law, por encontrar puntos que favorezcan esta armonización. Incluso en el caso de España, como saben, tenemos pluralidad de leyes. Se ha planteado si hay conflicto de leyes, si hay previsión de su armonización, si el reglamento de la Sociedad Cooperativa Europea del año 2003 podría servir para promover una armonización. Yo creo que no, porque queda muy alejado de lo que para nosotros es el derecho cooperativo, incluso de lo que es una cooperativa. En cambio, sí que los principios y valores cooperativos impregnan la legislación cooperativa en España y deberían de servir de columna vertebral para su armonización. Hemos tratado cuestiones particulares como el papel del capital social en las cooperativas, porque yo lo veo como un instrumento y las leyes lo regulan, sobre todo en España, muchas veces de manera que supone un freno a la constitución de cooperativas por la exigencia elevada de capital o incluso un freno a la entrada de nuevos socios. Y esto va en contra del principio de libre adhesión. También hemos hablado del rol que pueden tener las cooperativas en este nuevo contexto internacional de digitalización y de nuevas tecnologías de la comunicación. Yo pienso que es una oportunidad para las cooperativas y el derecho debe de ofrecer instrumentos suficientes que faciliten cómo regular esa membresía heterogénea, actividades cooperativas que se desarrollan en entornos virtuales, esas constantes transacciones internacionales en el interior de la cooperativa, entre cooperativa y socios, o cómo celebrar las reuniones a distancia. Con respecto a la revista, me preguntaban cómo creo yo que se podría mejorar la revista International Journal Cooperative Law. Creo que la difusión es muy importante y creo que se está haciendo muy bien. De hecho, este webinar es una clara exponente de cómo esto favorece el dar a conocer la revista y la riqueza que contiene, pero también creo que es fundamental que la revista esté bien posicionada en el ranking de revistas de prestigio, sobre todo para los investigadores, ¿vale? Para los investigadores y los académicos. Porque si una revista no tiene ni la consideración de revista científica, los trabajos que tú publicas ni siquiera se entra a valorar la calidad de los mismos. Por tanto, es muy importante fortalecer todo este aspecto institucional y creo que es el principal reto, en mi opinión, que tiene la revista. Por último, me pedían un consejo para los jóvenes investigadores. Yo a los jóvenes investigadores siempre les digo que es muy importante que se dediquen a la investigación en esta materia, su conocimiento es importante, hay muchas cosas que estudiar, hay muchas cosas que mejorar en el marco jurídico. Por otra parte, investigar en el cooperativismo es muy gratificante porque permite conjugar retos empresariales con valores sociales, como la equidad, la solidaridad, la ayuda mutua. Y eso hace que los investigadores en estas materias entiendan que merece la pena su trabajo y que contribuyen de alguna manera a un mundo más justo e inclusivo. Creo que es importante, muy importante, ser honestos cuando se es investigador y en todas las profesiones, por supuesto. Y también creo que es muy importante integrarse en redes desde un primer momento. Quiero recordar que en España hay una red de jóvenes investigadores en economía social muy activa y que ayuda a que se apoyen unos a otros. Bien, esto ha sido todo. Solo quiero agradecer a los autores de la entrevista por su interés, por su buen hacer, y a los directores de la revista por la oportunidad que me han dado de colaborar con ellos hasta el momento y desde un primer momento. Y por último, pues quiero desear mucho éxito a la revista y que cumpla pues todas las expectativas que se han puesto en ellas, porque hay detrás un equipo que vale la pena, que lo merece. Bueno, thank you very much, muchas gracias y merci beaucoup por el personal francés también que está aquí presente.
Muchas gracias, Gemma. Yeah, it was, as usual, very kind and very stimulating. Thank you very much. Just before giving the floor to Hagen for conclusive words, I'd like to thank everyone and all the people who supported the preparation of this webinar, notably Jan Adderley and Anne Apps, and of course the trio Iphigenia Hagen. And thank you very much to all the attenders. And now the floor is yours, Hagen, to conclude.
Thank you, David. Maybe not to conclude, but to say some words. I join you in thanking everybody in their various roles, which you just mentioned. You probably cannot imagine how gratifying this event has been for me for many reasons, but for one simple reason, and that is if we had organized a similar thing some years back, not many years back, some years back, it would have been probably maybe 5-person show, not more. And today we have, I think, several dozens of contributors and listeners, and that is very gratifying to see. The next point I would like to mention is maybe a few words on the activity of IUS Cooperativum, which has now a legal form. It's an association, and we of course invite you, should you not have done yet so, to join as a member. We have three main activities. One is the journal that we have discussed here. The other one is that we try to fill a world map of cooperative lawyers, so that you would click on that a country and find hopefully a colleague who is interested in cooperative law, whom you can contact for whatever question or try to collaborate with him or her. The third activity, main activity, is that we have been organizing fora on cooperative law international, the first one in Montevideo in 2016, then 2018 in Athens. This year, because of the pandemic, we could not organize it. It should have happened this year in Seoul on the occasion of the ICA Congress. It will take place next year, at the end of next year. And here I would like to invite you, again, if you haven't done so, to submit an abstract for a contribution to the forum, which has the overall theme of the harmonization of cooperative law and the identity of cooperatives. And that is an unofficial information, but will be confirmed in the next days. The call, the deadline, sorry, for the call will be extended again because of the reasons which I just mentioned. So there is still time, probably until the end of March, to submit an abstract. We will also co-organize with colleagues in southern Russia at the beginning of April next year a webinar, 6 and 7 of April, on cooperative law issues and trying to join hands or join minds with colleagues in Eastern and Eastern Europe, Russia, Central Asia mainly, but not exclusively. So that's all I had to say. Of course, concluding maybe with an invitation to contribute, as you did in the past, and those who haven't done so yet, to the success of the journal by sending in your articles and other contributions. Thank you very much. And again, it was a real pleasure for me to be part of this.